Good morning. Welcome to the Judicial Committee of the Privy Council, where today we are hearing an appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, Antigua and Barbuda, in the matter of Gordon and Havana. The two main issues on this appeal are, first, whether the Court of Appeal erred in finding that a payment of $3,000 was not consideration for 3 contracts for the sale of land, and secondly, whether a remedy based on proprietary estoppel was available. I'm Lord Lloyd Jones, and today I'm sitting with Lord Kitchin, Lord Burrows.
Good morning.
Lord Stevens.
Good morning.
And Lady Rose.
Good morning.
The appellant, Mr. Gordon, is represented by Tom Poole, Queen's Counsel, and Sarah Ibrahim. The respondent, Mrs. Havana, is represented by Dane Hamilton, Queen's Counsel. Mr. Poole.
My Lord, I'm grateful. My Lord, my Lady, I propose to follow the structure of our written case, which obviously we adopt and rely on. I propose to open the appeal by giving the board an overview of why we say the courts below fell into error and why we say that the fair disposal of this appeal is for the board to order a retrial. I'll then highlight some points arising from the evidence that we say have a bearing on the issues before the board this morning, then deal with the contractual grounds of appeal, and then deal with the proprietary estoppel grounds of appeal. By way then of overview, the appellant's overarching submission is that the decisions of the courts below are unsustainable because of various errors of law, which resulted, certainly at first instance, in the evidence in the case not being properly evaluated. If I can break that submission down into 4 opening points. First, we say that the trial judge failed to consider all of the evidence and made a number of irrational findings based on the limited evidence that he did consider. Now, that's not simply submission on the appellant's part. That is a finding of the Court of Appeal. And if I can take the board to 3 paragraphs of the Court of Appeal's judgment to make good that point, and starting at paragraph 27, which is page 424 of the electronic bundle. The Court of Appeal here is dealing with the trial judge's finding that there was no intention to create legal relations. And 4 lines from the bottom of paragraph 27, the Court of Appeal says, "I'm of the opinion that the judge failed to give the said evidence a balanced consideration and that his conclusion was rationally unsupportable, making his decision that the parties had no intention to create legal relations one that no reasonable judge could have reached." Right. The next paragraph, which to take the board to, is paragraph 29. The end of that paragraph is at the top of page 426 in the electronic bundle, where the Court of Appeal remark that the judge appeared not to have considered evidence as to the background to the contracts in question, and that his decision was simply not rational. And then finally, paragraph 31, which I'd invite the board to read in full. It starts at the bottom of page 428 and runs over the page to 429. It is, in my submission, a fairly damning indictment of the way in which the trial judge approached the evidence and made findings in the case. The second point to make by way of overview is having made those findings, we submit that they amount to effectively a wholesale failure on the part of the trial judge to properly evaluate the totality of the evidence, as we've seen from that last paragraph of the Court of Appeal's judgment. And having made those findings, we say it really was incumbent on the Court of Appeal to have remitted the matter and sent it back for a retrial, so that there could be a proper evaluation of the evidence at trial, with the trial judge hearing the witness testimony and being the primary trier of fact, rather than, as we say, what appears to have happened, which is the Court of Appeal attempting to determine the issues based on what at best, I submit, were findings at first instance without proper consideration being given to all of the relevant evidence. And it's really that defective trial process that resonates throughout the rest of the case, and I submit leads the Court of Appeal into the errors that I'll expand on in a moment. The third point we submit is when the Court of Appeal then consider the issue of consideration for themselves, they fall into error, because in my submission they proceed on the assumption that the contractual term for payment under the three contracts was a condition, and that a failure to pay at the time of signing was fatal to the contractual claim. Now, we do submit that the Court of Appeal's error is part explained by the failures at first instance of the trial judge to properly evaluate the evidence. And then, fourth and final point relating to proprietary estoppel, we say simply it's a claim that has not been properly considered by either of the lower courts. The trial judge, and I think this is common ground, dismissed the claim on what the Court of Appeal correctly found to be a wholly wrong basis. The trial judge effectively dismissed the proprietary estoppel claim on the basis that he found the appellant could not rely on a promise by the respondent to give him something which he effectively owned. Now, as the Court of Appeal correctly analysed, that fundamentally misunderstood the nature of the appellant's interest in two of the three plots of land. He had a leasehold interest over two of the plots, namely plots 116 and 117, which together comprise plot 59. But again, having found error in the judge's approach, the Court of Appeal then, we say, fell into error also because they refused to or failed to consider the proprietary estoppel claim because they found it arose out of the contractual claims. And we say that finding that they were effectively precluded from considering proprietary estoppel on that basis is wrong for two reasons. We say first, the Court of Appeal was wrong to construe the claim as arising solely out of an assurance or a promise to transfer land contained in the contracts themselves. In short, we say that the appellant's promise-based proprietary estoppel claim was distinct from the contractual claims, and all three necessary elements of a proprietary estoppel are made out, namely representation, reliance, and detriment. And I will, when going through the evidence in a moment, show the board the assurances and the promises that we rely on outside of the contracts, such as, to take an example, the representation that was made by the respondent that she had in fact gifted plot 117 to the appellant following their mother's death, which is recorded in a letter from the respondent, which the respondent admitted under cross-examination to writing. The second error in respect of proprietary estoppel in the Court of Appeal is really linked to the first point, but we say the Court of Appeal simply failed to analyse the nature of the right being asserted by the appellant. We say on a proper analysis, what the appellant was seeking to do by his proprietary estoppel claim was not perfect what had been found to be an unenforceable contract or contracts. He was seeking to protect an interest in land promised to him by the respondent, and that is perfectly permissible to found a proprietary estoppel claim in the circumstances. So, in short, for those four overarching reasons, we say the fair result would be for the board to remit this for a retrial. Dealing, if I may, head on with the concurrent findings point, and I will come back to this when dealing with the actual grounds, but I think it's probably important to address this straight away because my learned friend for the respondent attaches some weight to it in his arguments. We don't dispute the principles and practice of the board when it comes to concurrent findings of fact. What we say is that on a proper analysis, there are no concurrent findings in respect of consideration, because we say on a proper analysis of the judgment below, the findings made by the trial judge and the Court of Appeal with regard to consideration were addressing different issues. And as I say, I will hopefully make good that point when considering the contractual grounds. But even if we're wrong about that, and the board was to find that there are concurrent findings in respect of the consideration issue and the payment of $3,000, we do submit that this case falls within one of the exceptions to the general rule, because there has been an error of law in relation to that finding made at first instance, and that this would therefore be an appropriate case for the board to depart from its normal practice. And we submit the position is very different, for example, to that in the case of Das and Marchand, which the board has, and perhaps worth just turning to whilst I'm addressing this concurrent findings point. It starts at page 802 of the electronic bundle, and it's where my Lord Burrows set out the reasons behind the board's practice not to go behind concurrent findings of two lower courts. And it's really what is said at paragraph 16 and 18, which are at page 807. And what my Lord Burrows says, particularly paragraph 18, where he's outlining the second reason for the constraints of the board as an appeal court. He says, 4 lines down in paragraph 18, we agree with the Court of Appeal that there's no reason to doubt the findings and decision of Rampersad J. His judgment was thorough and clear and involved a careful analysis of the evidence, including the contemporaneous documentary evidence. Well, we say, as for the reasons I've already outlined, this is a very different case, and I really need go no further than the Court of Appeal's criticisms at paragraph 31 of their judgment. This is if I could say, a paradigm case really for the board, if there are concurrent findings in respect of consideration, to depart from its normal practice, because there have been errors of law. And by contrast to what is said in Das and Marchand, the board can have no faith in the exercise that was carried out at first instance. I can then turn to the evidence and highlight some material points. And perhaps before I do it, I think it might assist the board if I was to just identify on one of the plans in the electronic bundle where the various parcels of land we're dealing with are. If the board has 259 open, and if I can start with what is owned by the appellant that is not in dispute, just to identify those plots of land, those are plot 83, and what is described on this plan as Gordon House, which is also known as plot 38. Those are plots that are owned by the appellant, and there's no issue as to that. Plot 59 is the plot that comprises on this map 116 and 117. That was a single plot known as plot 59 until it was subdivided in 2001. And just for the board's note, the chief surveyor's plan showing that subdivision dated March 2001 is at page 270. And I understand there's no issue as to that subdivision. The respondent admits that subdivision in her witness statement in the Fernandez litigation, which is, for the board's note, at the top of page 279. What was plot 59 was owned by the respondent and the party's mother, Ruth Livingstone, as joint tenants. The appellant was granted a 99-year lease over that land on the 12th of January 1979. And there's again, for your lordship and my lady's note, the lease is at page 262 of the bundle. After the death of the party's mother in June 2000, legal title vested in the respondent. Now, the appellant's case is that plot 117 was the plot that was gifted to him by his sister following his mother's death, and that the 2001 contract that relates to plot 117 was entered into to formalise that gift. And I'll come back to that when looking at the evidence in a moment. So that's plot 59. Plot 60, adjacent to it, is owned by the respondent and is not an issue in this appeal. Plot 82 is, again, subject to what is said in this appeal by the appellant about his ownership of 82B. Plot 82 is owned by the respondent, and that plot was subdivided into 82A and 82B in 2007. And the appellant deals with that in his witness statement at paragraphs 15 and 16, which is page 221. Now, finally, by way of just background as to the land, the board will hear and has no doubt seen reference to the Fernandez litigation. And the board will hopefully, I don't think it's found its way into the electronic bundle, but it was sent either at the beginning of last week or the beginning of this week or the end of last week, a copy of a judgment in that litigation, which was a claim brought by the respondent against Mr. and Mrs. Fernandez. And the judgment is dated 30th of April 2007. But for present purposes, all I invite your lordship to make, and my lady to make a note of, is that that concerned plots 116, 60, and 82. And importantly, for reasons I'll come on to deal with, not plot 117. And one that's, again, can be seen if the judgment has found the board, and if not, I can make arrangements for it to be sent. We see that in the summary in the judgment at paragraph 2. It's judgment of Mr. Justice Blenman, and he defines what is the property in dispute as parcel 116, 116, 60, and 82. If I can now look at the evidence, and
Mr. Poole, a question from Lord Stevenson.
oh, I'm sorry, my lord.
Sorry, then page 493, the Court of Appeal got it wrong because he was in occupation of plot 59, which was subsequently divided into plots 116 and 117. I thought Mr. Fernandez was in occupation of plot 117.
My lord, as I say, if your lordship has the judgment in the Fernandez
Yes.
case,
Right.
it is the subject of that claim is plot 116, 60, and 82. Yeah. And I take that from paragraph 2.
Yeah, I may have the wrong reference. Thank you very much indeed.
I propose to look at the evidence by looking at evidence that relates to the 2001 contract first, and then the 2007 contract. And the reason I do that is because we say one of our complaints is that both lower courts, perhaps in particular the trial judge, failed to consider the 2001 contract and the two 2007 contracts separately. And as the board will see, there is some evidence that obviously applies with equal force to both contracts, but there is certain evidence that relates solely to the 2001 contract, which seemingly was simply not considered by the trial judge, and that is material to the issues on appeal. So dealing first with that 2001 contract, if I may, and this is obviously dealing with plot 117, the appellant's evidence in relation to that contract can be taken from the summary of the Court of Appeal at paragraph 30 of their judgment. And if I can pick it up at paragraph 30A, which is at the bottom, sorry, a third of the way down, page 427. What the Court of Appeal say there is that the contracts were executed, and the very nature of the documents suggests that parties...
Sorry, Mr. Poole, you're reading 427.
I'm reading 427, and it's little a.
Yes, thank you.
Starting all of these contracts were contracts reduced to writing and executed by the parties. And then about 6-7 lines from the bottom of that paragraph, the very nature of the document suggests that the parties did intend to enter into legal relations. And then over the page, little b, in relation to the contract for sale of parcel 117, so that's the 2001 contract, the appellant's evidence is that he sent copies of that contract to the respondent on 3 separate occasions, and on each occasion it was sent back signed, and on the last occasion it was dated. Again, this is accurate, obviously, summary of the evidence. And then at little c, the Court of Appeal make the point that the use of their words minor consideration, not reflecting true value, was a way for the parties to put a stamp of formality on what might otherwise appear to be gifts. Because, just pausing there, the appellant has never denied knowing that plot 117 and the other plots were worth more than the stated amount of payment in the contract. His case is that he was paying nominal consideration for all 3 plots of land. And that, in my submission, is important, as it was the appellant's case, as I've already outlined, that following his mother's death and the respondent's mother's death, that plot 117 had been gifted to him. And I said that was evidenced by a letter. And if I can just ask the board to turn up that letter, it's 268. And I made efforts to try and hopefully it has been put in a substitute of this document, because the original was very difficult to read indeed. And I'm afraid 268, 269 may not be that much better. But this is a letter written by the respondent. We know that it's dated November 2009 because the respondent confirms that in cross-examination, and the reference for that is 178. And it's written to the appellant. And for present purposes,
just say that date again, please.
November 2009, my lady. And it's the second page of the letter, the top of 269, second paragraph, where the respondent says, I really didn't need to give you anything, but the first thing I did after mother's death was to give you the beautiful piece adjacent to yours with the nice waterfront. Now, that is a reference in my submission to plot 117 being adjacent to what we've seen on the plan I took you to a moment ago, being Gordon House, the adjacent plot. The respondent gifting and then later selling by the 2001 contract plot 117 in my submission is entirely consistent with the Fernandez litigation. I've already made the point that that trial did not concern plot 117, and we say that is because the appellant during that litigation did not consider she owned that plot. She didn't consider she owned it after her mother's death in 2000, after the gift that was made to the appellant. But the respondent's evidence in that litigation is also telling, and we've got her witness statement at 279 from that litigation. At the very top of 279, she's confirming parcel 59 had already been separated into 116 and 117. And then 5 lines down from that, she says, at that point, I was not sure how I would handle the different parcels, but I did know that I wanted to deed some to my brother, Gregory Gordon, some to my daughter, Laura Hunsiker, and I was unsure if I wanted to keep a piece of the land to build in the future, as there's a great deal of emotion attached to the property for me. Parcel 116 was what I could give to my brother. Parcel 82 could be saved for my daughter, etc. And we say, again, this is consistent with the gifting of 117 at an earlier date, because it is only 116 that she is then, the respondent is then talking about as potentially a further gift to her brother. And we say, as well as that, the actions taken after the Fernandez litigation are also entirely consistent with the respondent disavowing ownership of plot 117. And we rely in this regard on 2 estate agency agreements that were entered into on behalf of the respondent in January 2018, and the board has at 389 the agreement for plot 60, and I hope it reached the board yesterday, the agreement for plot 82A, and if it hasn't, again, I can make arrangements for it to be sent, but I think it should have been sent yesterday to the board.
First plot, Mr. Poole.
First plot is plot 60, and the second plot is 82A.
Thank you.
And in respect of 82A, if the board hasn't seen the estate agency agreement, there's a letter in the electronic bundle at 387.
We've got a survey plan for 82A and an agency agreement for 82A.
My lord, yes, that's the document that wasn't in the electronic bundle that should have been.
Yes. Which do you want us to go to?
Well, my lord, if you look at the agency agreement for 82A, they're in identical terms, and the accompanying plan that confirms the plot that we're dealing with 82A. The point I'm making, the forensic point I seek to make out of those agreements, is that the respondent is looking to sell 82A and is looking to sell 116, consistent, I say, with her disavowing ownership of 117 and also 82B. But I'll come on to deal, because 82B is part of the, if you like, the 2007 contracts, and at the moment I'm just
forgive me. I thought the first plot was, you said, was plot 60. 60? Or
my lord, yes, sorry, my lord, yes, plot 60 and 82A, and sorry, my lord, I say that is therefore consistent with, if you like, the appellant's case, which is he owns, by virtue of the three contracts, 116, 117, and 82B, those being plots that are not being sold by the respondent when one looks at these agency agreements. Sorry if I confused matters earlier.
So sorry, you said three plots there. So you said she's disavowing ownership of 117 and 82B by the fact that she entered into these agency arrangements for plot 60 and plot 82A.
My lady, I should have, and my Lord Jones has reminded me that because we're dealing with plot 60, I should have added 116 as well. My focus at the moment is on 117 because that's the 2001 contract. 116 and 82B are, I say, dealt with under the 2007 contract. But this evidence of the agency agreements is relevant to all three plots that are in issue in this appeal. But my focus for present purposes was on 117 because I'm dealing with the 2001. My Lord Stevens.
Sorry, do we have a copy of the Fernandez lease? Because the reference at page 493 was paragraph 12. It's your own case in which you assert that he had a lease of plot 59, both parts of it. And so do we have a copy of the Fernandez lease? And whilst I'm on it, could we have a typed copy of this letter at page 268 as well?
My lord, you can certainly have a typed copy of that letter, and I'll put that in train immediately. I haven't got a copy of the Fernandez lease, and the reason that the judgment in the Fernandez litigation was late coming to you is because I sourced that after we drafted our written case, and so there may well be a mistake in our written case, which is why I rely on the Fernandez judgment. But I will make efforts, because I'm sure there is a copy, because there would have been a copy in the Fernandez litigation. And in fact, my learned friend for the respondent was acting for Mrs. Havener in that litigation, and so he might be able to assist as well. But I will certainly make efforts to locate a copy of that lease so that we can pin down precisely the land in issue.
Why did your client not pay the taxes on 116 and 117 by virtue of the fact that he had a lease from the 1990s? And he says he owned 117 in 2001.
Sorry, my lord, I missed the beginning of that question. Why
didn't he pay the taxes?
My lord, I think his evidence is that he did pay the taxes, although not through
for 4
his
years. Only for 4 years in 2007, 2008.
Yeah, yes, my lord.
Up to 2010. Why didn't he start paying the taxes in the 1990s?
By the way, he doesn't deal with that in his evidence, and I can't speculate. He says that there was a nominal rent charged for that, for his leasehold interest in 116 and 117, and it's not in issue. I think the respondent confirms in her she's cross-examined about the lease, and she says her evidence at 144 is that she may have granted the appellant a lease. But it's fair to say that the lease of 116 and 117 did not feature heavily at first instance.
Did he repair the seawall in 1980 at a cost of $20,000?
But I can't based on the evidence that we have, I can't say either way.
And was that $20,000 included in the $193,000?
Well, we have a schedule. We have a schedule of expenses at 260, and so that's probably the answer to your lordship's question. I think the answer, looking at item 1, is yes. Labour to repair what looks like 100 feet seawall for parcel 117 and reinforced seawall, $53,000.
But that was in fact in the 1980s.
My lord, yes, and these are the expenses that can make up the 193,000 that the evidence is that the appellant paid for.
So upon what date was the assurance given to him about the gift of 117?
Well, his evidence is that he was aware after his mother's death that 117 had been gifted to him, as confirmed by the respondent in that November 2009 letter.
Where do we find the clear, unambiguous representation in relation to 117?
My lord, we find it in the November 2009 letter, which is the respondent's own evidence, and in the appellant's witness statement that deals with this.
Yeah, perhaps I've taken you out of your course. I'm sorry.
No, my lord, because these are important points. But what it also comes down to as well is these are all points that were not properly analysed by the trial judge, which is why I hopefully take the realistic approach in this appeal, where I'm not inviting the board to effectively step in and make findings. That's why realistically we do say that this is a case that properly needs to go back and be heard at first instance, and all of the evidence evaluated properly in light of witness testimony and the contemporaneous documents. Just dealing, though, I'm finishing off on the 2001 contract. I've dealt with, if you like, what the appellant says and what some of the documents suggest, and certainly inferences that can be properly drawn from those documents. But the respondent's defence in my submission is telling in respect of that 2001 contract. And her defence is set out at paragraph 8 of the defence document. It's page 206. And the defence was that the appellant secured the execution of the 2001 contract in breach of his relationship of influence as a fiduciary. That's the defence. Now, there are a number of problems with that defence. Just if I highlight two of the fundamental problems, is that it is common ground that the appellant was not granted power of attorney until November 2005. So that's 4 years after the 2001 contract was signed by the respondent. The second problem with the defence, in light of the first instance judgment, is that the trial judge made no findings that any of the contracts were procured by intimidation or in breach of fiduciary duty. And the Court of Appeal note that at paragraph 27 of their judgment, which is page 424. Turning to the respondent's testimony and her evidence at trial, and we can take this fairly quickly, because she effectively said she had no recollection of the 2001 contract, but she did recognise the signature as her signature. That was her evidence. And if I just give the board the references to that, no memory of the contract at 137, no recollection of signing the contract in respect of parcel 117 at 155, and when the signature was shown to her, she agreed that it was her signature. That's at 139, lines 1 to 6. Perhaps unsurprisingly, the respondent was cross-examined about that November 2009 letter. And again, her evidence is quite telling about this. We see this at 179 of the notes of evidence. The question is asked, did you give it to him? And the answer given, it was not unofficially done, but now I have changed my mind. Now, presumably, what is meant is it was not officially done in the sense of there's no written contract at that point in time, but it's hardly a denial in my submission of gifting the appellant plot 117. And perhaps the more damaging point is that it is quite clear from her evidence that the change of mind comes in 2007. And we see that from her evidence at page 150, lines 12 to 22. And that is critical when we're considering the 2001 contract and plot 117, because that is after payment of the $3,000 in February 2006. But again, the bottom line is that none of this evidence was properly evaluated by the trial judge as it should have been. And it was impossible in my submission for the Court of Appeal to make the necessary findings to allow it to fairly determine the issues arising in connection with plot 117, whether as part of the contract claim or whether as part of the proprietary estoppel claim. If I can next just highlight some evidence that bears on the 2007 contracts. Those are the contracts in respect of 82B and 116. We've already seen that the respondent's intention, as expressed in the Fernandez litigation, was that she could give plot 116 to the appellant. Now, the appellant's case was that the 2007 contracts were formalising that gift in the same way as the 2001 contract was formalising the gift of 117. And as I hopefully clarified because of the confusion that I created about the agency agreements, I do say that the agency agreements are relevant to the 2007 contracts as well. They are consistent with the respondent recognising that she was not the owner of plot 82B and plot 116, certainly as at January 2018. Now, the respondent's defence again to the 2007 contract is telling. She said that they had been procured in breach of fiduciary duty. That's paragraph 6 of her defence at page 205. But that was rejected by the trial judge, but who then went on to dismiss the contract claim on the basis that there was no intention to create legal relations, which the Court of Appeal have correctly said was an irrational finding. But again, and sounding slightly like a stuck record, and I apologise, but we say the point is this evidence in respect of the 2007 contracts was simply just not properly evaluated by the trial judge. If I can move then to the contractual grounds, we've addressed these at paragraph 30 to 37 of our written case. And I propose to deal first with the failure of consideration point, and then the contractual remedy point very briefly. Perhaps before considering how the Court of Appeal addressed the issue of consideration, it is probably necessary to just outline what I say the problems are that they faced as a result of the first instance judgment and how the trial judge wrongly dealt with this issue. And I make 3 points in this regard. The first is this: the judge deals with consideration and intention to create legal relations together at paragraphs 16 and 17 of his judgment, which is pages 15 to 16 of the bundle. And in my submission, when one reads those paragraphs, the judge is conflating the issue of consideration with that of the intention to create legal relations. And having wrongly found there was no intention to create legal relations, that has materially influenced his finding that there was an absence of consideration. And at the very least, in my submission, he did not feel it necessary, having found there was no intention to create legal relations, to carry out the necessary evaluation of the evidence surrounding the making of the contract and the payment of $3,000. And in that regard, I say the Court of Appeal actually agrees with us. And we see that from paragraph 31 of the judgment, which is page 428, where they find that the judge wrongly concluded there was an absence of consideration. That's one of the many criticisms they make of the judge in that paragraph, that he wrongly concluded that there was an absence of consideration. Now, the second of my 3 points is we submit that although the judge refers to an absence of consideration at paragraph 17 of his judgment,
Mr. Poole,
my Lord,
just before you leave that point, but surely the Court of Appeal are saying something rather different than you're implying. They're saying there was consideration, that is, the promise to pay $1,000 in relation to the first contract or $10 in relation to each of the other two. It had nothing whatever to do with your implication, as I understand it, that the $3,000 payment in relation to what is alleged to be the Fernandez litigation had anything to do with it. I don't think you can draw in aid what the Court of Appeal was saying about consideration, can you?
My Lord, it is. I think what I can do is obviously point to what the Court of Appeal have said about the judge's conclusion of an absence of consideration, and that has to be read in the context of that paragraph as a whole, which is I think they say a wholesale failure to consider the totality of the evidence. And I do say that supports my conclusion that I urge on the board, which is that there was a conflation of the two issues of consideration and intention to create legal relations. But perhaps I leave it there, because I would accept the point that, and I'll make this point in a moment, which is one of the answers to the concurrent findings, which is that when the lower courts are talking about consideration, they are talking about it in two different respects in my submission. And this does lead on to this second point that I'm making, which is when the judge is referring to an absence of consideration at paragraph 17 of his judgment, what he in fact means is a failure to make payment at the time of signing the contracts. But as the Court of Appeal say, and I think this is my Lord Borough's point, what they say is that obviously a failure to make payment does not ex post facto mean there's no consideration or there was no intention to create legal relations. And that one does see from paragraph 35 of the Court of Appeal's judgment, which is page 431. The third and final point, though, on what I say are the difficulties that will face the Court of Appeal because of the defect of the trial process, is that the timing of payment was not the only material matter before the trial judge when determining this issue of consideration. And yet the judge refers only to the timing of payment. And in so doing, we say fails to consider and evaluate three important matters. And those three matters are, first, the appellant's evidence that the payment of $3,000 was made at the respondent's request and on agreement that the land would be transferred to him. And that's in his witness statement of paragraphs 28 and 30 at page 225. And his evidence at trial was consistent with that. And he also gave evidence in cross-examination that the respondent did not ask for the $1,000 in respect of the 2001 contract. And the reference for that evidence is page 100. As to the respondent's evidence, though on the payment, the respondent's testimony confirmed that she received $3,000 from the appellant in 2006 and used it to pay lawyers in connection with the Fernandez litigation. And we see that from her cross-examination at 146. And the effect of that evidence on the trial judge is recorded in the first instance judgment at paragraph 10, where he records, summarising her evidence, she also said she received $3,000 from the claimant, which she used to pay the legal fees of her counsel in the Charles Fernandez case. There's no analysis by the trial judge of the party's testimony as to what that £3,000 was for. And there's certainly no reasoned rejection of the appellant's evidence as to what that was for. The judge's reasoning effectively boils down to, that's a payment made in 2006, and it cannot possibly relate to a contract entered into in 2001 just because of the effluxion of time. And in my submission, that's not good enough, given the evidence that was presented to him. And the second important matter that there's simply no evaluation of is the respondent's witness evidence in the Fernandez litigation that she wished to deed some of the land to the appellant and that she could give parcel 116 to him. And the respondent accepted in her cross-examination at trial that that was her intention up until 2007, so i.e. a year after the payment of the $3,000. And I've given the board the reference to my lady.
If she wanted to gift it to him by deed, why didn't she do that? Why wasn't there a deed of gift of this land to formalise what she had promised?
My lady, the answer to that is that the parties could well have done that, but the manner in which they, in my submission, decided to formalise the gifts were in these three contracts, and that was the appellant's evidence. And I've got nothing to explain why they didn't do it by way of deed, as your ladyship identifies they could have done. The third matter that I say was not evaluated is the respondent's evidence that she had changed her mind about the nominal consideration for the 2001 contract of $1,000 in 2007. And I say, because of the judge's finding that there was no intention to create legal relations, there was simply no consideration of those three important pieces of evidence, no evaluation of that evidence. And that left the Court of Appeal in an impossible position in my submission. And if we go on to look at how the Court of Appeal dealt with consideration, I say they very much started on the back foot because of the defective trial process. And because of this finding by the trial judge erroneously and irrationally that there was no intention to create legal relations. But there are two further criticisms we do make of the Court of Appeal's reasoning. So the first, obviously, is they should have simply sent the matter back for a retrial. But having decided to consider the issue themselves, the first criticism is we say the Court of Appeal was wrong to dismiss the contractual claim on the basis that a failure to pay at the time of signing the contracts was fatal. We say that fails to consider whether, in light of all of the evidence surrounding the contract, the payment term in the contracts was itself a condition. Now, I accept that purchase price is stated to be payable on signing, but it is not stipulated in the three contracts to be a condition. Now, a condition could be implied, obviously, by the circumstances surrounding the contract. But again, there's nothing in the Court of Appeal's judgment, and certainly nothing at first instance to suggest this was part of the Court of Appeal's reasoning. And if, on the other hand...
Isn't there a problem in your path here, Mr. Poole, that the Court of Appeal addressed the question as to whether this was open to you? at paragraph 36.
Sorry, paragraph 36 of the Court of Appeal's judgment, my lord.
Yes.
Sorry, I'm probably being slow on the uptake.
Not at all. It may be my fault, but this is the pleading point that's taken against you.
My lord, I hadn't. Sorry, and this is obviously me being slow on the uptake. I hadn't appreciated that there was a pleading point that was either being taken against me or that had been found against me by the Court of Appeal.
36, based on the following, the parties had the requisite intention to create legal relations, but the appellant never paid the consideration. In an attempt to remedy that,
my lord.
The point is made that that there was no attempt to rescind the contract. This links in, doesn't it, with your point about the requirement of payment at signing not being a condition. And that the court ought now to consider the willingness of the appellant to pay the consideration at a later stage. So the court is addressing this question. It's saying it's not open to you to take the point. Your case, as I understand it, Mr. Poole, which you're now advancing, is that the Court of Appeal was wrong to dismiss the contract claim on the basis that failure to pay at signing was a condition. And your case is that the payment could have been made at a later date. I think you're on mute, Mr. Poole. I'm sorry, we've lost the sound.
Oh, sorry, my lord. No, our case is not that we could effectively make this right by now paying the consideration, although that was what was offered by the appellant as a sort of fallback argument in the Court of Appeal. We say that the consideration was paid in 2006 by payment of that check for $3,000. The point I'm seeking to make is that the Court of Appeal's analysis has to be that the payment of the purchase price at the time of payment was a condition. And I say that is not borne out by their reasoning or by any of the findings at first instance, which is one of our reasons why we say that this is a case that needs to go back for reconsideration. I mean, it may well be found on the consideration of all of the evidence that it could be implied into the contracts that payment had to be made at the time of signing. Or if, on the other hand, for example, if the term as to payment is properly construed as an intermediate term, then I can see that the entitlement of the respondent to repudiate would depend on the seriousness of the consequences of the breach. But again, that would need to be considered in light of all of the evidence.
So is this your case that they were wrong to say it was a condition? It was not a condition, so payment could be made at any time. That the respondent never said anything to make time of the efforts of the essence. So she never said, right, pay me by the end of next week, or else it's all comes to an end. And therefore, if it's possible as you say it is, that the $3,000 was in fact payment, then that was payment in time, because it wasn't a payment on signing wasn't a condition, and payment and timing had not been made of the essence at any later stage. But that depends, I think, on the $3,000 being the consideration for the 2001 contract, rather than on you taking a point, well, now I'm ready and willing to pay, which was what they said, what the Court of Appeal said was not okay.
Yeah, my lady, that's precisely it. And you're right, it does depend on the payment of the $3,000 being consideration, or being payment under the for the 2001 contract, the $1,000, and then the two lots of $10. It would have to be past consideration for the 2007 contracts. And
yes, thank you. I understand that. Thank you.
But perhaps just dealing.
My Lord Stevens has a question. I think.
Of course.
To be absolutely categorical, you are not relying upon the fallback argument made in the Court of Appeal. That is, that you can pay now.
Oh, no.
I mean, you've just said so.
No.
And I wanted to be absolutely and utterly clear about it.
My Lord.
Yeah. And also, perhaps the trial judge did take a view. If you go to page 14, and I think it's paragraph 10, he has some difficulty. Paragraph 10. So it's earlier on. It's paragraph 3, page 13. His last sentence of that paragraph certainly doesn't reflect well on your client's evidence and his view about it.
My lord, I take that point, but the difficulty is that there has been, again, I apologise, I've said this now a number of times, that there has been, as found by the Court of Appeal, a failure to consider all of the evidence.
No one's explained to me how you get $1,020 into a payment of $3,000. I mean,
well, my lord, perhaps if I just deal with this payment point, because our overarching submission in respect of this is that the finding that the payment of $3,000 was not related to the 2001 contract, and that's really what the judge's finding in inverted commas at paragraph 17 of the judgment, page 16. I do say that was a finding that was made without any proper evaluation of the evidence. Now, the appellant's evidence at trial was that the respondent did not ask him for $1,000 in 2001, and that he paid the $3,000 in respect of all 3 parcels of land when it had been agreed that the land would be transferred to him. That's his cross-examination at page 62. And that's consistent with his witness statement at paragraph 28, page 224. And as I said a moment ago, the respondent's evidence on payment was simply to confirm that she received that $3,000, and it was that she used it to pay the lawyers. That's her page 146. There's no analysis in the judgment or by the Court of Appeal as to what that $3,000 was to be used for, and certainly no, in my submission, rejection of the appellant's evidence. Yes, I accept at the end of paragraph 3, it's noted that there's no explanation as to how the balance of £3,000 was to be applied, but the inference is that the £3,000 was to be used by the respondent to pay the lawyer's fees, and the £3,000 was paid, but that was paid to meet the $1,000 owed under the contract in 2001, and to meet the nominal consideration for the 2007 contract of $20 in my submission. But these are matters that would need to be properly, my Lord Barrows.
Yes, can I just take you to the Court of Appeal at paragraph 35 at page 427?
My Lord.
Because they seem to me specifically and very clearly to be looking at this point and to be saying that the judge was clearly entitled to reject the evidence of the appellant that the $3,000 was effective to provide the consideration for the contract. They've looked at the payment of $3,000, bearing in mind the timelines, and we've got effectively 5 or 6 years after the first contract and prior to the other 2 contracts. The date when it was paid, the amount paid, that is, it didn't tie in, the circumstances, the judge was on the evidence, clearly entitled. You've got a finding at first instance backed up by the Court of Appeal. I mean, we can't do anything about this, surely.
My lord, I certainly say you can, because I say on a proper analysis of that finding, that is a finding that has been made simply focusing on the length of time between 2001 and 2006. There has been no evaluation at first instance of the party's testimony as to why that sum of money was being paid and what it was being paid for. The Court of Appeal, yes, acknowledged the finding, but I say that the finding at first instance is vitiated by an error of law and an error of approach. So I do say that this is a case, unlike the case of DAS, where the board should depart from its normal course. My lord, my lady, Lady Rose.
So is this what you're saying? It's quite a subtle distinction between what you say the judge thought that he had found, which is that the money was paid by, the $3,000 was paid by Mr. Gordon to meet the legal fees and had nothing to do with the consideration under the contract, as contrasted with he paid the consideration under the contracts, and in fact she used it to pay the lawyers. But that's fine, she can use whatever money she has to pay the Fernandez lawyers. In fact, he paid the consideration and she used that, but that doesn't detract from the fact you say that the payment was of the consideration and not some completely separate payment intended by both of them to be payment for the Fernandez lawyers. Is that the
my lady? That is what I say, and that's why I've identified where it's dealt with by the respondent in her evidence, because her evidence is solely to the use that she made of the money. Now, it of course would have been open to the trial judge to have made the alternate finding and rejected the appellant's evidence that he was paying that $3,000 as part of the consideration and part of the consideration both sets of contracts. But there's no rejection of that evidence, and I do say that that is part of the difficulties that the Court of Appeal encounter when they rely on that finding. My Lord Stevens.
When was the $10 agreed? Because if he's paying the consideration before he enters into the contracts, when was the amount of consideration agreed?
Well, my lord, the evidence is silent on when the amount was, but his case is, and his evidence was, that it was prior to the contracts being executed in 2007, when the payment of the $3,000 was made in February 2006. The reason he was making payment then is that's because it had been agreed at that point in time that the land would be transferred. That's, if you like, the trigger for payment. In February 2006.
How did he know not to pay $5,000 or $6,000?
Well, my lord, because his evidence is that there was agreement that it would be nominal consideration.
What's that mean?
Well, my lord, I mean, here you might have a sort of a pound. You might have but there it was $10. $10 is consistent with obviously the notion of nominal consideration, and the Court of Appeal, I think, referred to it as minimal consideration.
But why then do you get $1,000 in the first contract, which is also said to be nominal?
Well, again, it is not. I can't speculate because it's not dealt with in the evidence. It may be thought that 117 has more value to the appellant because not only is it adjacent to his own property, but it's on the waterfront. But
I mean, can I
as I said,
take you back, because I'm still troubled by this point. Forget Death and Marchant and any practice of the board just for the moment. I mean, what the Court of Appeal is saying is, we've looked at this evidence, and what we find is that what the judge was clearly entitled to do was not to tie up the $3,000 as consideration. Now, that's a Court of Appeal view of the evidence. How can we go behind that just as an ordinary appellate court? I mean, what's the error of law?
well, my lord, the error of law is the error that's committed at first instance in making that finding. And with respect, I don't read the Court of Appeal at paragraph 35 effectively saying, having identified that the judge has not carried out, as he should have done, a proper evaluation of the evidence, we have considered all of the evidence in this case, and we consider, as a Court of Appeal, carrying out that evaluation exercise ourselves, that the judge was entitled to make that finding. What the Court of Appeal, in my submission, are saying at paragraph 35 is the judge has found that the $3,000, because of the time it was paid, namely 5 years after the contract being entered into, is not related to that 2001 contract. And we are making a finding because of our, I say, wrongly considering it to be a condition. We are making a finding that it had to be paid on signing. And because it wasn't, there was no payment in respect of that 2001 contract. Because that's what the Court of Appeal is saying. That's different from the first instance judge, who simply is relying on time and not carrying out any analysis of whether this is a condition or time is being made of the essence, or carrying out any evaluation of the party's evidence as to the reason for the payment. So I do say that there's an error of law at first instance in respect to this finding. The Court of Appeal and the judge are looking at it from two different perspectives, and so they are not concurrent findings. And even if I'm wrong and they are concurrent findings, then I do say that this is an appropriate case for the board to step in, because there has, to go back to the paragraph that I've taken the board to a couple of times now, there has been a wholesale failure at first instance to consider the totality of the evidence. My Lord Stevens.
I'm sorry. So was this a plank of the appeal to the Court of Appeal that the matter should be remitted to either the trial judge or a new judge? And was there also a ground of appeal to the Privy Council that the trial judge had made so inadequate findings of fact that the whole matter should be returned back?
My Lord, taking those points in turn, I think the appeal to the Court of Appeal, you see the grounds of appeal at starting at 4, and then at EB5.
Sorry, page, Mr. Poole.
So 4, my Lord.
4, thank you.
And at page 5, there are findings of fact being challenged, a number of findings of fact. And just looking, the orders sought are 10. It's not expressly set out there that what is being sought is a retrial. I would accept that. But obviously, it is clearly within the power of the Court of Appeal in an appropriate case to make an order.
But I was just wondering why, when we're in the Privy Council and neither the ground of appeal nor, as far as I understand it, the Court of Appeal were asked to send it back to the trial judge. Why, after all that expense, we should now do so? Well,
my Lord, I'll be corrected if I'm wrong by those instructing me, because what we haven't got are, as we sometimes have, the submissions that are made to the Court of Appeal, which often sort of expand on the grounds of appeal and clarify the grounds of appeal. And so I can't I cannot definitively confirm whether a retrial was sought to the Court of Appeal. But I will take instructions on that, perhaps over the short adjournment.
Yeah. And the second question being, is there a specific ground of appeal to the board?
That, my lord, I'm just looking whether I can answer that by reference to the documents. You have the appeal at 445, appeal notice at 445. And perhaps, my lord, rather than take up time with me turning pages, if in 5 minutes we'll take a short break, I will go through those documents and I will confirm one way or another whether there is express reference to part of the relief being a remission to a retrial, if I may. I think what I can certainly say is that one reads the appeal grounds, when one reads our case, it is quite clear that what we are saying is that there has been a complete failure at first instance to properly evaluate the evidence. But I appreciate that doesn't directly answer my Lord Stephen's point. If I may, just in 5 minutes we've got before we take a break, just finish off on ground one. And I said that there were two criticisms, and I've outlined the first criticism, which is we say a failure to analyse properly whether the term could be construed properly as a condition. The second error we identify is that the Court of Appeal did not consider the contract separately. So we say that the Court of Appeal should have asked itself whether the payment of $3,000 was a failure of consideration for the 2001 contract, and then given separate consideration to the 2007 contracts. And for the reasons that we've already outlined, we say that there's a good argument based on the respondent's own evidence that the 2001 contract was valid and enforceable, as that related to a parcel of land, namely parcel 117, that she said herself she had gifted to the appellant, and in respect of which she had only changed her mind in 2007 after payment of the $3,000. And then further, in respect of the 2007 contract, the Court of Appeal should have considered whether payment prior to those contracts amounted to past consideration, or whether it was done at the respondent's request. Again, there's a failure in the Court of Appeal to analyse the contracts in those ways. And dealing very briefly with the question of contractual remedy, we deal with this at paragraphs 31 to 37 of our written case, pages 500 to 502. But the short point is this. There was no evidence led by the respondent that would render specific performance inappropriate, and nor were there any findings made at first instance that would bar specific performance. Now, obviously, if this were remitted for a retrial, then the issue of specific performance could be considered in light of all of the evidence, as too could be case for contractual damages in the alternative. And just dealing with one point that my learned friend makes in his case in response, I think it said at paragraphs 31 and 32 that we didn't ask for repayment of monies expended on the land. Now, insofar as necessary, because that would obviously be a matter for determination if a retrial is ordered, just to give the board the references to the amended pleadings. Paragraph 9 of the amended statement of case sets out the sums expended on the land. That's page 197. That refers to a schedule which is referred to in the pleading as GG6. That's the document that I took my Lord Stephens to a moment ago, 197. Paragraphs 24 and 26, back to the pleading, plead damages in the alternative to specific performance. That's 199. And it is plainly the case that the respondents were aware that there was a claim for damages being pursued because it's dealt with in their defence as distinct from a claim for specific performance. And we see that from paragraph 12 of their defence at 208. And the question of damages was also dealt with, albeit briefly, in the evidence. Just give the board the references at page 51 to 52. There's confirmation in cross-examination that the appellant expended those monies on his own behalf, page 60. and then he's cross-examined at pages 179 to 180 about the expenditure. My lord, my lady, if that's an appropriate moment, I'm moving on to the proprietary estoppel grounds of appeal.
Thank you, Mr. Poole. We'll take 5 minutes. Mr. Poole.
My lord, I'm grateful. Just before moving on to proprietary estoppel, if I just give my Lord Stevens the best reference I can. Paragraph 48 of our written case obviously makes the point that we're inviting the board to remit the matter to the High Court for a retrial. That's page 505 of the electronic bundle. It's fair to say there's no express relief of that nature pleaded in the notice of appeal, but I would make the submission that when one reads the complaints that are made, that amount to a number of allegations of a failure to evaluate properly the evidence, that that is what is significantly hinted at and then is made plain in our written case. Proprietary estoppel we deal with at paragraphs 38 to 47 of our written case, and it's obviously an alternative to the contractual claim. If I can begin by just outlining what the proprietary estoppel claim is, first really by reference to the pleadings. The claim is pleaded at paragraph 19 of the amended statement of case, which the board has at 199, where it's pleaded that the claimant avers that the defendant, through her conduct, is estopped from denying the rights of the claimant to the possession of and beneficial and legal ownership over the 3 parcels of land. The conduct relied on there, namely the conduct of the respondent, in my submission is the conduct that's pleaded in the foregoing paragraphs. If I can just outline what I say that is. It is the entering into the 3 contracts, but it is not limited to the entering into the 3 contracts. Paragraph 11 of the statement of case at page 197. The representations contained there are being referred to the November 2005 memorandum. Now, the November 2005 memorandum that's referred, I think it's given the exhibit number GG8. That is, give the board the page in the bundle. It's page 402. That is a document that was entered into in November 2005. And it's the top of that page, the respondent saying she wishes to my brother to receive 50% of any and all proceeds received from the sale of such lands at Diane in Antigua. That is one of the representations relied on. That's what's being set out at paragraph 11. Also, paragraph 13 of the statement of case 198. Sorry, paragraph 13 of the reply, apologies, which is page 215. And there's a reference there to GG8. And the representations made by the defendant both verbally and in writing. GG8 again is that memorandum that we saw referred to in the statement of case. Paragraph 12 of the reply, if one turns back a page to 214, that's referring to the November 2009 letter. That's the letter at 268 that the board's already seen, referring to the gift upon the party's mother dying in 2000 of plot 117. Paragraph 17 of the reply, 216, refers to representations that parcels 116 and 82B would be sold for minimal consideration. And paragraph 19 of the reply refers to written and oral communications about family arrangements as seen in GG15 and GG16. And just to clarify what those exhibits are, GG15 is the November 2009 letter, that's 268. GG16 is a letter the board hasn't been taken to yet. It's the letter of the 16th of March 2010 from the appellant's lawyers. It's at 398. But what that letter records is really the appellant's instructions, which is the 2/3 of the way down the page, where he says, "You have repeatedly communicated to Gregory that these properties are his." So that's merely recording, obviously, what the appellant's contention is.
Yeah.
We can also see from paragraph 40 of the Court of Appeal judgment, 434, how the representations were put in closing submissions at trial. And the point is this, really. There were representations in my submission that were relied on by the appellant, in addition to and separate from the 3 contracts. And in fact, it was the appellant's case that the purpose of the 3 contracts was to formalise what had already been promised to him. If I can turn then to how the claim was dealt with at first instance, and deal with this briefly. The trial judge, as I said earlier, wrongly dismissed the proprietary estoppel claim because, my lady Rose.
Sorry. So just to be clear, the letter in November 2009 that you refer to, that's obviously a representation made after both the contracts. So I'm not sure that you could say that the contracts were entered into to formalise that. But are you saying that those are evidence of some earlier?
My lady, yes. I say that the November 2009 letter is evidence of an earlier representation made in effectively what would have to be after June 2000, when the party's mother died. Because what the respondent is saying in that November 2009 letter is, I've gifted you parcel 117. Now, there would have had to have been communications between the parties as to that gift of parcel 117. And we say it is those representations or that promise or that those actions that is being evidenced by the November 2009 letter.
Was there any evidence of Mr. Gordon in his written or oral testimony about what that letter is referring back to?
My lady, yes, he deals with the letter, perhaps unsurprisingly, because he attaches significant weight to that letter. And he deals with it. Let me just get the best point in his witness statement. So paragraph 18 probably is certainly one point, page 222. Based on the defendant's representations subsequent to my mother's death, I maintained and improved this parcel and hired staff to maintain the whole of parcel 59. This was all done with the knowledge and approval of the defendant. And this is having referred earlier in his witness statement to the November 2009 letter. It being effectively his case that he was promised on his mother's death parcel 117, and that was what was gifted to him, and that was then what was confirmed in the 2009 letter written by the respondent, which she admits to having written.
But we don't find anywhere the date of a conversation or the contents of a conversation or anything of that nature. All you do is a generalized statement, if I may say, at page 222.
My lord, yes, I can't. It is not the words spoken are not set out when these representations precisely were made. But what I say, when one pieces it all together, what is clearly being said is that when the party's mother died, parcel 117 was gifted by the respondent to him, and he relied on that, we say, to his detriment. And that is being confirmed by the respondent in the November 2009 letter. As to proprietary estoppel at first instance, as I said, the Court of Appeal judgment deals with this in paragraph 21, 422, and there's no cross appeal from that. Effectively, the trial judge just got it wrong. The trial judge made a finding that because the appellant had a leasehold interest in parcels 116 and 117, then that was fatal to his proprietary estoppel claim, because he couldn't effectively be promised something, as the judge wrongly said, that he already owned. Really, we need to focus on proprietary estoppel in the Court of Appeal, and we deal with that at paragraphs 37 to 43 of the judgment. Paragraphs 37 to 43 is where it's dealt with in the Court of Appeal's judgment. And we submit that the Court of Appeal made 2 errors. And if I just outline what those errors are and then expand on them. The first is the failure to analyse the nature of the right that the appellant sought to protect by his proprietary estoppel claim. So was it a contractual right or an interest in land? And then relatedly, second, we say the Court of Appeal failed to properly consider whether other assurances made by the respondent, in addition to and separate from the 3 contracts, could have given rise to him reasonably believing and therefore relying on a particular interest in the land. And perhaps if I add a third error, it is similar to the error in the contract claim. There's no analysis separately of the various plots of land. For example, it might be said that there is a stronger claim in respect of plot 117. Now, taking those 2 errors in turn, we submit that even if the Court of Appeal was right to look solely at the contracts for the assurances that were relied on to support the proprietary estoppel claim, the Court of Appeal should still have gone on to consider the claim, as opposed to making a finding that they were precluded from doing so. And what we say in paragraph 40 of our written case is that a promise to transfer land can obviously give rise to a proprietary estoppel, even if the contract could not take effect because, for example, they fail for lack of consideration or because they don't comply with formal requirements. And we refer at paragraph 40 of our written case to an extract in Tritle, which the board has at page 1049, where proprietary estoppel and contract are contrasted. And we don't see that as a controversial proposition of law. We also rely on the principles that are set out in the very well-known cases of Thorner and Cobb, which we've summarised at paragraphs 24 to 29 of our written case, which is 497 to 499. And really, at the heart of this complaint is that we say that the Court of Appeal simply focused solely on the formalities of the contract rather than the wider factual matrix and the evidence about the appellant's reasonable expectations. And this is obviously tied up with the criticisms I've already made of the first instance judge. Had there been, we say, a proper evaluation of the relevant evidence, the Court of Appeal would have seen that the appellant was not using estoppel as a means of protecting an otherwise unenforceable contract on the Court of Appeal's finding. His proprietary estoppel claim was trying to protect an interest in 3 plots of land that he said he had been promised by the respondent. And we say what the Court of Appeal's analysis also fails to take into account is that this was not a commercial relationship, but it was more a domestic family relationship. And we refer to what Lord Walker said in the Cobb case, and perhaps if I can just ask the board to have 786 open, which is Lord Walker's judgment in Cobb. And 5 lines into paragraph 68, he says, in the commercial context, the claimant is typically a business person with access to legal advice, and what he or she is expecting to get is a contract. In the domestic or family context, the typical claimant is not a business person, not receiving legal advice. What he or she wants and expects is to get an interest in immovable property, often for long-term occupation as a home. Focus is not on intangible legal rights, but on the tangible property which he or she expects to get. And the reason I cite that is I do say that we are in more of a domestic family relationship, and where the focus therefore should be on the reasonable expectation of the appellant. He wasn't expecting by his proprietary estoppel claim to, as I've already said, to effectively perfect an otherwise invalid or unenforceable contract. He was seeking to protect an interest in land. And as we say, paragraph 46 of our written case, the necessary components for proprietary estoppel, namely representation, reliance, and detriment, were all evidenced before the lower courts. And I do say there's no basis for the board to conclude that had the proprietary estoppel claim been properly considered, it would have been unsuccessful. And that's another compelling reason in my submission for the board to order a retrial. And the second point, my lord,
sorry, just before you go on, I can see very well that one might have a proprietary estoppel claim where a contract is void or otherwise defective. But the situation, as I understand it, that you're faced with here is a valid contract that has been breached by your client. Have we any example in the case law of proprietary estoppel being used by a contract breaker in this sort of situation?
Well, look, I would say what we have here is a contract that is unenforceable, invalid through a failure of consideration is what we have. And what one
when you say failure of consideration, you mean non-payment by your party, by your client. It's a breach, isn't it? It's not failure of consideration.
Well, on the findings of the Court of Appeal, on their analysis, that yes, there's a condition that payment had to be made on signing, and that payment was not made on signing. So yes, I would accept on the Court of Appeal's analysis, it is a breach by the appellant.
So we're not dealing with a void or an unenforceable contract. We're dealing with a valid contract that has been a breach by the party you're representing.
But my lord, if on an evaluation of the evidence, the reason for the breach is effectively failure to pay nominal consideration, and the promises and assurances that are relied on are in addition to and separate from the contract, then I say there is nothing, because ultimately with a proprietary estoppel claim, it's to remedy unconscionability in the assertion of strict legal rights. And I say in those circumstances, there's nothing, to put it the other way, there's nothing unconscionable by the appellant asserting a proprietary estoppel claim in those circumstances where there has been the promise, there has been the reliance, and there has been the detriment.
But I think that was going to be your second point about this being separate from the contract. But at the moment, I thought we were on your first supposed error, that there's something about a difference between a contractual right and a right in land.
Well, my lord, I do say that there are 2 points, but I accept that they are related. They are related points because one informs the other to a certain extent. But I do say that on a proper analysis, what the appellant is trying to enforce here is not a contractual right. He is not trying to, as I say, perfect a contract that he, to adopt Lordship's word, has breached for failure not to pay. He is asserting an interest in land by his proprietary estoppel claim.
And the problem I'm then going to face is what the Court of Appeal said at 40 and 41. I mean, they looked at these submissions, that these representations were somehow separate from the contract, and as I understand it, rejected that.
But again, my lord, the problem is, and this is really the same answer I gave to your lordship's similar question about the contractual grounds, they are on the back foot because there has not been an evaluation of all of this evidence. So, for example, the November 2009 letter and its impact on this claim is not evaluated. And that's an important piece of evidence. And so I do say, I accept what the Court of Appeal say, but I say the difficulty with it is that they have not got the benefit of proper evidence-based findings at first instance.
Thank you.
My Lord, Lord Stevens.
I was just wondering, is it unconscionable to deny the appellant a benefit which could have been achieved under the contract if he had abided by its terms?
My Lord, I say, on the circumstances of this case, no, given that the payment was nominal consideration and given that it was effectively to formalise a gift that had already been made to him. I can certainly see in other circumstances and in a different case that it could be said to be unconscionable. But I say on the facts of this case, yeah, it can't be said to be.
Well, I have difficulty about the facts of the case. What you're doing is contrasting the 192 with the nominal consideration of $1,020. But the appellant has a lease of this land for 99 years. And that is part of the reason why he pays nominal consideration. And so the expenditure can be equally explicable on the basis of that. And also, I really have misgivings about making claims for cutting the grass, giving rise to a proprietary estoppel. And that is what is included in his schedule. Finally,
My Lord,
I've got difficulties about the fact that the respondent lived in America, and how much of all this she knew. There are absolutely no findings about that. How much she knew about this expenditure that was being taking place. I have great difficulty in understanding it.
well, my Lord, the inclusion of the cutting the grass is because no doubt the appellant was asked by his lawyers to include all expenditure that he has incurred in respect of the properties. But obviously the heart of the expenditure are the more significant amounts. But I do go back to my point that one has to look at all the circumstances of the case, and on the facts of this case, because it wasn't, and I take your lordship's point that yes, he has a 99-year lease over 116, 117, but his evidence was that was but one factor into the reason for paying nominal consideration. A significant factor was also the assistance that he gave to the respondents in the Hernandez litigation. He said that he was effectively the only person in the family that would assist her in that regard. And so it is all of that evidence that I say just hasn't properly or at all been evaluated. And the claimant, the appellant, is faced with a position where his proprietary estoppel claim was not considered at first instance entirely irrationally. And then the Court of Appeal, faced with incomplete findings based on an analysis of not all of the evidence, were, as I say, very much on the back foot and fell into error in the two regards that I've said. And the second, which your lordships and my lady has already heard, which is, I say, on a proper analysis of the claim, there were promises and assurances outside of, additional to, and separate from the three contracts. And that's another reason that the Court of Appeal erred when they considered the claim. And for all of those reasons, we do say this is an appropriate case for an order to be made ordering a retrial. My lord, my lady, I finished a bit short of my allotted time, but unless there are any questions, they are my submissions. Sorry, my lord, you're on mute.
I'm sorry. Just to make it absolutely certain, the part performance has also been abolished in Antigua, is it?
Sorry, my lord, I missed that.
Part performance, the doctrine of part performance, is also abolished in Antigua as well. Because in a sense, this is part performance and the old-fashioned concept of part performance.
Yes.
But that is also no longer the law. Is that right?
My lord, I would need to confirm that.
Thank you. I don't think there are any further questions at the moment, Mr. Poole. We're grateful to you. We're going to adjourn now briefly to take stock of where we are. So we'll adjourn the hearing for the moment. Thank you. Mr. Poole, we're very grateful to you for your submissions. Mr. Hamilton, we don't need to call upon you. The board will presently take time to consider its decision in the matter and the advice that we will tender to Her Majesty. Finally, I should thank all counsel and those instructing them in this case for the preparation of the bundles for the hearing, for which we're grateful. The court will now adjourn. Thank you very much.